screen. But I have been practicing law for over 23 years. I was at one of the big firms in Baton Rouge, specializing in labor and employment law. You heard me earlier. I'm currently a partner at Boyer, Hebert, Caruso, and Agel. And what I want to do, as April indicated, is make this very interactive. I will give a kind of a brief overview of, some of the legislation that has been enacted since our nation is dealing with this pandemic, and now the back to work issues. So I'll give you a little bit of an overview, but it doesn't do me any good just to tell you what I know if that's not pertinent to you. So we want to make this interactive. I know many of you, some I don't, I know the names, and I've not had the pleasure of meeting yet. If you do not have audio or video, just make sure that you put your question in chat. If you would prefer to raise your hand, toward the end, we just use the, kind of the hand raising, and we'll kind of get to you in that context as well. Let me start by saying this and preface this though. There's going to be several things that there simply is not a definitive answer on yet. Any of you, I heard that several of you are HR specialists and deal with these issues often, so you kind of feel my pain when I tell you that. But you have to understand kind of how we're there and why that's the case. These acts and some of the legislation that we're going to talk about, Congress passed in record fashion. I mean, they spent a week to 10 days passing 1,000-page legislation. That typically takes many months, and that typically is vetted and debated, and all the stones are unturned, and people are able to see what nuances may trickle out of, some of this legislation. They simply didn't have the luxury to do that here. And so we're having to now figure this out either after the fact or take our best guess on some of these things. You'll also note that the legislation typically comes with regulations that provide guidance and definitions and interpretations, and it allows us to interpret how that act is to be passed. Well, in this case, much of that guidance and those regulations are either coming out after the fact, or they're not even out at all yet. So, so some of this stuff, like I said, we're not going to have necessarily a yes or no answer, but that's pretty much the commonplace with these topics anyway. So briefly, let me kind of take us back to the beginning of March, when it became apparent that something needed to be done to try to, put some preventative measures in place. One of the first things, other than the president, having, his discussions and suggestions, OSHA issued some guidelines. It was, I think, March 9th. It was the beginning of March. And essentially what they were trying to do is prevent worker exposure or minimize worker exposure. So OSHA's guidelines essentially suggested, it wasn't a law, it wasn't a statute, it suggested that employers implement a plan, develop some sort of a workplace plan, and then implement controls, workplace controls that would help minimize worker exposure. Some of it was simply emphasizing things like employee hygiene. It was emphasizing things such as, if you're sick, don't come to work. If you've been exposed to someone who either believes they have tested positive or is experiencing symptoms of the COVID-19, to stay home, to quarantine for 14 days. So all that general guidance that now we're all very familiar with, because not only OSHA, but the CDC has developed more and more guidance in the past 2 months, and and a lot of our, some of the best practices suggestions is going to be contained in that piece that April mentioned earlier. Because as April and I, we appointed a task force to kind of help. It was an LP, Livingston Parish Task Force for businesses trying to navigate the return to work issues. And so a lot of that information is going to be contained there. But the next thing that came out is, I believe it was March 18th, the president signed the Families First Coronavirus Relief Act. That act was intended to provide some protection for employees. The two main components of the Family First Act were a new type of Family and Medical Leave Act, FMLA, called the Emergency FMLA Leave, and also what we called, or what they called, the emergency sick leave component. So the emergency FMLA applied, as did the sick leave component, to employers with under 500 employees. There is an exemption for healthcare workers, first responders, and the FMLA is kind of narrow, though. It only allows, or it allows up to 12 weeks of leave, the last 10 of which are paid at 2/3 of their rate, but it allows that leave only if you are unable to work because you're caring for a child who is unable to go to school or daycare because of closures. Okay, now the emergency sick leave was much more broad. It also included that same component as far as eligibility for the sick leave if you are caring for a child or, because of daycare or school closures. But it had several other components that would make employees eligible to receive that leave if they either had experiencing symptoms of COVID and they are seeking treatment, if they've been exposed to someone who has been diagnosed as positive, if they themselves have been diagnosed as positive. And there's kind of a catch-all if you just fear that you may catch it because of, other issues. So, those two components really sought to provide some, some security and some money for employees. And the way that Congress sought to offset this cost to the employers is it allowed the employer to apply for tax credits. So the employer was able to eventually make this a wash with the tax credits that they were ultimately going to be entitled to. But the problem is it didn't help employers with their short-term cash flow issues. The employees that were eligible were applying for and receiving this emergency leave and were being paid according to the various guidelines of the act, but no relief in sight until they were able to offset with these tax credits. So at the end of March, Congress passed the CARES Act. We're pretty familiar with the CARES Act. I'm certain all of you business owners or involved in business, you know that one of the big components of the CARES Act was the Payroll Protection Program. So the PPP program allowed employers to apply for a loan, and the loan amount is based on your average payroll costs. And so your maximum loan amount would be 2.5 times your average payroll costs, up to a $10 million cap. And what the good thing about this loan is that if the employers use the loan in accordance with the act, primarily to pay their employees, then the loan would be forgiven. Essentially, it turns into a grant. And so there's several, kind of specifics. Several of you are CPAs. I know you guys have been just as active and involved with this process through the SBA as we have here. But the gist of it is, if you spend, you have an 8-week period to spend the money from when you close on your loan. If you spend 75% of it on payroll costs and up to 25% on other eligible things such as either rent, mortgage interest, or utilities, then the bank is able to then forgive the loan and convert it into a grant. So that was a very big boost. As you all know, the first $350 billion was exhausted within a week. Congress added another $300 billion, I believe. And I know that we got a client approved last Friday. I'm not certain. I actually haven't checked this week to see. Trey, you may know if they've already exhausted all that money. But I know if they haven't, it's getting very close because it was already toward the end of it then. Another component of the CARES Act, though, was it dealt with unemployment compensation. And one of the things that the act did, is it first allowed more people to become eligible for the unemployment compensation that typically wouldn't have been eligible to apply. It also provided that if you are unemployed and unable to work because of COVID-19, that you would also be eligible to receive a federal stipend of up to $600 through July 31st. And so many of you probably have employees that either you had to lay off or because of other issues did not come back to work and are on that unemployment. And we'll deal with that when we talk about the forgiveness. And I'm sure some of you probably have some questions because there are several things. As I mentioned earlier, the SBA and the Treasury Department have been issuing updates and notices as to how employers are to ensure that the loan becomes forgiven. One of the very big concerns that many employers, many of my clients, and I know some of you probably face is, well, what if my employee was laid off or furloughed and they started receiving unemployment benefits? Now they're making $850 a week, which may be more than what they made with me, or at least close enough to justify them fishing instead of coming back to work. How am I going to still be able to meet the full-time equivalent component of the payroll protection program? Fortunately, the new guidance that came out late last week, early this week, did establish that if the employer makes a written offer for the employee to come back to work at the same pay, the same hours, and that employee then declines that offer, then that employee not coming back will not jeopardize, it will not count against you when the forgiveness calculations are done. So that was good news from employers because it was going to be an issue where it was going to be a juggling act. I know when we got to the forgiveness stage, how do we ensure for employers that that this loan is converted to a grant. Now I know those aren't technically HR or employment issues, but because the employees themselves are involved, we've still been dealing with that as well.
So let me ask you, Todd.
Yes.
So how the key is getting that in writing. So if you got an employee that's kind of MIA, is there a secret to that? Has anybody had any problem with that? Because I can tell you, if somebody's kind of gone,
you're going to have to send it certified mail.
It's going to be really tough.
Yeah, something like that is going to, if you don't have email access with that employee, then what I've been suggesting is send it certified mail. It's somewhat similar to the payday statute. When an employee separates from employment, you've got a timeline within 15 days of that separation or the next payday, whichever comes first, you have to pay them all wages that are then due and owing. It doesn't matter when they get it. It matters when you tender that payment. So I tell clients all the time, send it certified registered mail where you can prove when you sent it. That's the same thing I'm telling clients in this context as well. Have proof that you sent it. Now, the problem, April, is going to be we have to establish, it says that you have to prove that the employee declined to come back. So we'll obviously be able to infer if I've sent them a certified letter, I've documented that I have tried to call, I've texted, I've sent emails. The documentation is going to be the key.
Right.
And again, here the bank is going to have a lot of latitude. I'm not certain. I didn't hear anybody. Well, actually, I think I did hear somebody with a bank that during the introductions. The banks are going to have a lot of latitude here. If you talk to the bankers, they may say, it's just getting dumped in our lap to make this decision. But whether it becomes forgivable once you've been able to document what you've done, that you did offer that employee their job back, again, same pay, same hours, and they don't come back, then my belief is that it should be forgiven, and it will be.
We do have another question on here. So Kim would like guidance on someone who chose to self-quarantine. So you may be having that, some of you, or maybe you even know family members who, now that things are reopened, they're a little tentative about going to work because they may be in a vulnerable age. So they haven't contacted them nor returned to work. So is it fall under the same thing you just mentioned?
Well, and that's, so I was about to get to the return to work issues too. Before I go there, Kim, I'm gonna get right to it. But one other thing I was gonna just point out, that it's just a common thing that I've seen a lot of my clients not really struggle with, but have questions about, and that is just kind of some basic wage and hour issues. So understand that your obligation to pay your employees, is whatever your agreement was. If they're an exempt employee, you have to pay them the guaranteed salary. 864, I believe is what it is now. For any work week, you got to pay them the full salary if they perform any work during that work week. Your non-exempt hourly employees, or they don't have to be hourly, but your non-exempt employees have to be paid for all time spent working. So one thing to be mindful of in your business or for some of your clients is that includes time spent working at home. So you need some protocols, some procedures in place to be able to track what work is being done, what the employee is actually doing, so that you can ensure that you've properly paid them. And whatever questions you have on that, I'll answer those. But kind of, Kim, to get to what I was leading into next is where we're at now, and this is the murkiest of murky and the grayest of grays, and that are the return to work issues and employer liability, exposure, for if you force an employee back or if they've chosen to self-quarantine. All of these issues are kind of merged into where we're at now. And I can tell you, I read this every day. There's several things that I follow and try to follow up with on, what can be done to help minimize that employer risk and exposure. And basically what you're going to have to do is rely on several basic things that we already know. Don't make decisions based on a protected class. So when you're trying to determine what to do with this employee who has self-quarantined or simply refuses to come back to work, you start with the premise of, I'm not going to make a decision based on their age, race, sex, disability. And disability becomes important here because some are liking this pandemic and symptoms that they may develop from it to a disability. Okay, so if someone has a weakened autoimmune system and that's the reason they're not coming back, then again, I can't give you specific advice, but I would generally tell you, I don't advise that you simply fire them because of that. You need to take it further. Each of these are going to be on a case-by-case basis. You're going to have to walk through the analysis of, is this employee eligible for the FMLA leave that's been granted? Because, I kind of, since a lot of you are involved with this, you already, I assumed a lot of facts, one of which is FMLA in general only applies to employers that have 50 or more employees or public employers like Jody. All right, so, some of you, FMLA is a whole new concept. You've never had to provide unpaid leave or 12 weeks of leave for employees. Well, now you have to, because it applies if you have less than 500 employees. So these, perhaps that person that's still at home and won't come back to work is eligible for this emergency FMLA or the emergency sick leave. We're going to have to analyze it in that context as well. There are going to be some issues to where if the employer forces someone or insists on them coming back to work and they have not taken adequate precautions, put in plans to help try, or at least to attempt to minimize worker exposure, that it very well could cause some liability. Walmart has already been sued. I forgot what state, but I was reading the case. There were 2 employees that, once this pandemic hit, if you tried to get into Walmart or some of these other stores, you realized that they were still very busy. Well, 2 employees ended up dying, and now there is a wrongful death suit because they're alleging that at that time, and this is somewhat early on in this process, the suit alleges that Walmart did not have protocols in place. They did not have the mandatory, sanitation station. They didn't have the PPE. They didn't have masks. They didn't provide the employees with either the knowledge or the equipment necessary to try to help protect them. And so obviously I don't know the outcome of that case, but I think, it's going to be a very tough thing for employers. So you have to start with those basics. There is now plenty of guidance and information out there from the CDC, from OSHA, and from many other sources, state and local, that will help you in developing that plan and implementing some controls. But again, if an employee refuses to come back or if they contract, then there's still issues that employers are going to be dealt with. And I know some of you, we've had this conversation, that Lobby, our local chamber, or I guess is the state chamber, they act in that capacity, is advocating very hard for some protections and some guidance that would allow employers to not, have this kind of exposure and liability. They're trying to come up with some, legislation, even at the state level, that will protect employers from that, because who knows if someone does contract it, who knows where they got it. That, in my world, causation is going to be a tremendous legal issue. But the reality is, in that Walmart example, I mean, if this guy just goes to work and home and they have no safety protocols, or at least not adequate safety protocols in place, and they end up contracting it, in that case, unfortunately died, inevitably there's going to be, someone out there that's going to take a case like that.
It's going to be really tough to police all that stuff too.
It is. So what, do we have any other questions on chat, or we can just kind of, if you raise your hand, again, we'll try to address it. I haven't really been reading that as much, so April, just read it out if you see it.
No, got it. I've been keeping up with it, and trying to like prompt people to ask things that are coming through in particular situations for them. Has any of you had a hard time getting a hold of the cleaning supplies and such that you need in office? Those are some of the things that you have a hard time getting. I mean, some of them we can't always find and access the wipes that go along with it. Those kind of things. Have already been able to access those? Because those should really be part of your return to work plans as well. Everybody's been good with that? Good.
So look to the information that our task force is putting out, that April has started disseminating. It's going to have a lot of these best practices. It's going to have some general guidelines, and we would like your input as well, as how the chamber can help your businesses in this process. We're going to, and April and Christine have already been very active in, like letting you know what restaurants are open and things like that, and other businesses. And, we're coming, is there can we make a business COVID compliant? Well, all we can do is take all of the information that we have and try to do, what we're calling the best practices. There's not, yes or no question, yes or no answers to these questions, but we do want your input. Some of you have asked this very question too already, but we do want your input on how the chamber can help serve you in this process as well.